and seeking answers which you didn't provide in your main statement and or your supplementary statement, particularly the question set out in paragraph 2.1 of Regulation 10.6 notice. You recall?
Yes, I recall.
Okay. Now, sorry, 2.2, my error, 2.2, yes, of the notice. We had gone as far as item 2.2.5 of that notice about exchange of information, if you recall. Mr. Matlala?
Yes, I recall.
Okay. And there are other issues set out in paragraphs 2.2.6 and 2.2.7. Now, both those paragraphs required you to, in the context of the relationship you maintain with General Sibia, to speak to whether you have ever given or offered any gift, gratification, monies, sponsorship, favors to General Sibia. That is 226 and 227. Inquired whether you have requested or been offered any favors by General Sibia. Do you understand?
Yes, I do.
Now, that's going to be quite an involved engagement, so I'm going to stand down that part of the engagement regarding your relationship with General Sibia, and just to let you know, we will come back to it, and Advocate Hassim will deal with that part of things with you at the appropriate time, okay?
Okay.
So I would like us to move off this topic then, which would lead me to a position you assume in your supplementary statement, if you could turn to that. You recall there are a number of questions posed to you in response regarding the recordings that were made following your arrest, following your engagement or interrogation by SAPS or members of the SAPS in December 2026, as well as following your arrest in May 2025, no, the first year is 2024. I'll try again. In December 2024, and your arrest in May 2025. They are the recordings you refer to that you say have been furnished to you, and you deal with those recordings in your supplementary statement. You confirm?
Yes, I confirm.
And yesterday you have time and again expressed a view that you would not be answering any question relating or arising from such recordings on the basis that you understand that you are a suspect and you are being investigated in respect of matters discussed in those recordings. Did I understand you correctly?
Yes, that's true.
I trust that your exhibit file has been updated. And my understanding is that you were given an assurance by the NPA that you are not being investigated, or such recordings are not being utilized for purposes of investigating you, thus rendering you not a suspect as you feared. Are you aware of the assurances provided you by the NPA in that regard?
Maybe my learned friend can just direct me to the where she gets this information from, this assurance that she refers to, and what does it exactly relate to, or how. I wanted to understand where she gets the information that she currently raises and relies on. The issue of the assurance given by the NPA that he will not be prosecuted for anything pertaining to these recordings. And these recordings, does it now mean it's recordings relating to
To a point where she says, I have failed to do so, then I suggest that she's got no basis to be interrupting my examination of the witness. So, if you will, I've posed the question to the witness. I would like the witness to answer.
Chairperson, with the greatest of respect to my learned friend, when you pose questions to witnesses, again with respect, you need to have a basis on which you make a certain statement. And it's all I'm asking, is there a basis that she relies on? And it's not necessary to become aggressive about it. I simply am here to do my job. I'm asking, is the statement that she makes that assurances have been given, does it have a factual foundation? And if so, can we please just understand what the factual foundation is? Otherwise, what we are busy with here, with the greatest of respect, is to try and catch my client at this point with certain statements that made. If there is a foundation for a factual foundation, then just give it to us. There's nothing that says I'm not entitled to ask what the statement is based on.
In the interest of progress, may I make this suggestion, which I think in the circumstances is a practical suggestion. Yesterday we made very good progress with Mr. Matlala regarding broad or blanket attempts at asserting the privilege against self-incrimination. We referred specifically to paragraph 109 of the unanimous judgment of Justice Jafta, and we said there must be specificity as to the crime in respect of which the privilege is being claimed, and then the basis, that is, in the context of that crime, the basis upon which the privilege is being claimed. It cannot be broad, it cannot be generalized, it cannot be blanket. May I suggest, Ms. Sello, in the light of that, so the fruitful ground that was covered yesterday should, in fact, I think at some point I did say that it covers the entire spectrum, which means it covers even the recordings. It cannot simply be said, for whatever reason, that the recordings are a no-go area. So with that as the springboard, as it were, can I just ask you to, Ms. Sello, to ask your questions that relate to the recordings, and let's see how Mr. Matlala, aware of the legal position I took him through, responds to your specific questions.
Thank you, Chair.
Thank you.
Mr. Matlala, my question to you regarding those recordings, has the NPA ever given you an assurance that matters recorded in those recordings do not currently form part of, are not subjects of any investigations? Are you aware?
No, I'm not aware of that,
Okay.
Commissioner.
Then may I refer us to Annexure CJC 442? That is the letter, Commissioner Khumalo, you asked about. That would be file 11. It's now being shared with you, commissioners, and the witness.
Thank you.
So Annexure CJC 442, that would start at paginated, it's paginated 1. This, Mr. Matlala, as you can see, is a letter from the Director of Public Prosecutions. If you go over leaf, next page, it's dated the 6th of March, 2026. And this is addressed...
Is the flickering on the screen indicative of imminent flighting?
I think so, Chair.
All right, thank you.
And it's up. And that letter is addressed to Hlawu Maluleke attorneys. Do you confirm those are your attorneys of record?
Yes, I do confirm.
And the subject line reads, the state versus Kekana and 2 others. Your client accused 3 Vusimusi Matlala. And then it gives detail of 3 cast numbers. And in summary, it says it's regarding conspiracy to commit murder, attempted murder, unlawful possession of a firearm and ammunition, money laundering. If we could read the letter together, it reads as follows. 1, your correspondence dated 6 March 2026 under reference V. Matlala has bearing. So this is a response to a letter written on your behalf by your attorneys to the Director of Public Prosecutions. As already confirmed in email correspondence to your counsel on Monday, the 2nd of March 2026, only a selected portion of the recording was made public at the Matlala Commission. 3, the state, in parentheses, including the investigating team, close parentheses, do not have a transcript of this or any portion of the recording. If you wish to obtain a transcript of the portion made public at the commission, you are welcome to approach them for it. The audio of witness C's testimony in relation to the interview with your client made public at the commission is readily available on several social media platforms like YouTube, for instance, and can therefore be accessed by yourself. It is thus considered unnecessary to provide you with same. 6, furthermore, it is once more reiterated that, emphasis, nothing in the whole interview forms part of any police dockets currently before court, simply because it is not relevant, and therefore does not form part of the evidential material against your client in the matter currently before court. It is finally recorded that the portion not made publicly available to the commission contains sensitive information relating to an ongoing investigation, and the defense is therefore not entitled to this information. Do you see that?
Yes, I do.
Now, will you agree with me that the fact that those recordings may incriminate you, or what is stated in those recordings may incriminate you or in any manner infringe your constitutional rights against self-incrimination, are not applicable in the matters that you currently face? In particular...
No, continue.
In particular, the matter under reference here, which I think you refer to as the Pretoria matter.
Not Pretoria, the Johannesburg matter.
The Johannesburg matter.
Yes.
And I call it the Johannesburg matter to distinguish it from the Medicare matter. That's
yes.
correct.
Yes.
Were you referring to recording singular or to recordings? And as I understand it, there are more than one.
I understand that this is the order.
Initially, before you read the letter, were you referring to recordings plural?
I was referring to recordings plural.
Plural, yes.
And if I may explain, Chair, if you have regard to paragraph
because
5.
I'm looking, for example, reading paragraphs 5 and 6 together.
Yes.
They refer to witnesses' testimony.
Yes.
And the interview that was at issue there. So the specific reference is in paragraph 5. And then 6 refers to interviews singular, obviously referring back to paragraph 5. So that would, I would imagine, relate only to one recording, and there must still be others. And if your question, which introduced the present debate, related to recordings, plural, I'm not sure whether there isn't a difficulty with regard to what the NPA says
I'll
about
try.
the recordings not being relevant to any criminal proceedings that Mr. Matlala may be facing.
If we take a step back, Chair, witness C, when witness C...
perhaps also maybe let me add this. And then I think paragraph 7 complicates it even more. Because there, the NPA says, You are entitled to the interview singular referred to in paragraphs 5 and 6, and that's readily available. You can get it online. It is on platforms like
Yes.
YouTube, so you can get it there. But then 7 complicates it by saying, the rest of the recordings or interviews raise sensitive material which relates to underlying in ongoing investigations,
Indeed.
which then brings that within the fold of possible or potential crimes that Mr. Matlala may face.
I'll try and address them in turn, Chair.
Yes.
The Chair will recall that when witness C testified, I think witness C introduced 2 recordings, and they were played in this forum. And these are the recordings that Mr. Matlala wanted. I am aware that at 5, the wording is witness C's testimony and refers to the audio. But by right, it's audios. And that may very well be a typo, because in their communication, it doesn't appear like there's a distinction drawn between any of the 2 audios. The position assumed by Mr. Matlala in his affidavit is he wants all audios that were played here through witness C, flighted here in the commission, and the full, because there wasn't the full audio in respect of each inquiry. But the full audios have since been made available to him. So in response to whether it is 1 audio or 2 audios, I suggest that it is in respect of both audios, because nothing before us and in this letter distinguishes the one from the other. If the Chair has regard to his paragraph 9, it's page 9, sorry, and that is a paragraph 35.
It's a supplementary.
Supplementary, my apologies, supplementary affidavit. And this
Page 9 paragraph, I'm very sorry.
page 9 of the
35.
supplementary, paragraph 35. That should
thank
be
you.
read with paragraph 32, where Mr. Matlala states that he only learned that his interrogation and his responses were electronically recorded at the time. The dates provided at paragraph 35, the 6th of December 2024 and the 14th of May 2025, relate to those interrogations and the recordings. And as I say, all have now been provided to him. This response from the NDPP is in respect of the recordings that he says he subsequently learned were made during his interrogations, and he requires those recordings for purposes of this, I think he says it's the Johannesburg case.
My learned friend,
May you
she might
please-
not be
please-
finished at this point. I'd like to address you.
Please let her finish, please.
I got the impression she was finished. That's why I said I would like to
You
respond.
came in mid-sentence, Ms. van den Heever, please.
Thank you, Chair. So that is so far as the witness C's, that's insofar as witness C's testimony is concerned. It's the 2 recordings, it's the recordings that were played through witness C in this forum. That deals with the issue at paragraph 5. Now, I must say, the YouTube clip referred to at paragraph 5, I haven't watched, so I'm not in a position to tell whether it is all these audio clips in succession or otherwise. So that insofar as witness C's testimony is concerned. The further question that the Chair asked me is regarding paragraph 7, which references ongoing investigation. Now, that paragraph states that the portion not made publicly available at the Commission contains sensitive information relating to an ongoing investigation. It doesn't identify what investigation. It doesn't suggest the investigation is against Mr. Matlala. It could very well be investigations pertaining to other issues where he is not a suspect. I submit that it is not a basis simply because SAPS is investigating to then seek to invoke or to assert the right not to incriminate himself. It takes us back to paragraph 109 of the Concord judgment, which is when the question is posed, that is the point at which to determine whether there is a risk that the witness will incriminate himself. What any other interpretation would suggest, because there is an investigation involving inter alia, an interview that Mr. Matlala had with the members of the SAPS, then those issues cannot be traversed in this commission because there is an investigation. The letter doesn't even suggest that Mr. Matlala is under investigation for whatever it is that the NDPP suggests is subject to ongoing investigations.
Perhaps a difficulty I have, Ms. Sello, is not having an idea of where you are going, but where I'm sitting now, what you appear to be doing is the flip side of what Mr. Matlala was doing, and which I said he cannot do. Asking him, I'm again referring back to your very first question, and I'm not referring to what you say now in respect of the content of the letter. My sense from what you did right at the beginning about the recordings, plural and in general, does not focus on specifics in the sense that this recording says this, and here's my question about that, Mr. Matlala. What is your response?
Yes.
That is what I would prefer than asking a broad and generalized question about the recordings, if you see what I mean. That places Mr. Matlala in a difficult position, I think. So that is what I was trying to say. Maybe I did not convey it clearly when I said I have a practical suggestion, and that perhaps what you should do, Ms. Sello, is to ask specific questions relating to the recordings. That is what I had in mind, rather than these close to, the first one was indeed broad and generalized. Maybe your later question relating to the letter it still comes very close to, to being broad, to my mind. But as I say again, maybe that's because of where I'm sitting and not knowing where you are going. But I would prefer a situation where you say, there's this recording. This is what I want to raise with you about that specific recording. Here's the question. What is your response? I think we will make a good progress if we approach it that way. And we do that in the context of what we have already explained to Mr. Matlala yesterday. So he will not and should not give us yesterday's broad and generalized responses. May I plead with you to please
No, Chair, it's not necessary.
I'm still going to give you an opportunity, Ms. van den Heer.
It's not necessary to plead with me. What I suspect perhaps happened, I was not as articulate as I would have hoped to be.
Yeah.
The purpose of reading this letter was simply to deal with the concern that Mr. Matlala raised yesterday, wherein he suggested that those recordings involve investigations in which he's a suspect. It was at the broad level.
I think we are past that stage now.
Yes.
We are past that stage now, and Mr. Matlala sitting there. I even directly spoke to him about the legal position, and I think I remember him in so many words saying that he understood what I was conveying.
Then if he understood, it takes care of my issue, because yesterday, the bulk of the issue, I think, the engagement with Mr. Matlala was in regard to the criminal cases in which he's an accused. Yeah. Then he raised this issue of being a suspect because there are ongoing investigations. There is another matter in here for which I think Ms. Cordelia, I forget her surname, I apologize, has provided
An affidavit.
an affidavit, and those are investigations by IPID. So these are different investigations that I am referring to. And the point I seek to make to the witness is that you are not, contrary to the position you assumed, you are not under investigation currently.
I want to assure you that I will not allow Mr. Matlala to say nothing about those recordings because I'm being investigated. He will, in accordance with paragraph 109 of the Constitutional Court judgment, have to specify a crime for us to have a better idea as to the basis upon which the privilege is being asserted.
I'm happy to leave it at that on that basis, Chair.
Thank you very much,
Thank
Mr. Law. Ms. van den Heever?
Thank you, Chairperson. I promise to look and see and watch her light until it goes off, so as to not create the impression I'm trying to interrupt her, because that was not what I was doing. I got the impression she was finished. First of all, this letter was in response.
Do you still want to address this?
Yes,
Because
indeed.
I think now we've, after my engagement with Mr. Law, I think this is done and dusted.
Chair,
But let me hear you.
There's three issues I'd like to raise. First of all, this letter is in response to a very specific request, and the request related to the statement that was made by Mr. Matlala on his arrest. So it dealt specifically with the statement that was made in May of 2025. That statement we submitted, we entitled to under the provisions of Section 335 of the Criminal Procedure Act. So I want to make that clear. Maybe if my learned friend had the preceding letter, she would have understood.
May I ask to say something, please? I wonder if any of that matters now, because the upshot of my engagement with Mr. Law is that her engagement with Mr. Matlala on the basis of that of the content of that letter no longer arises. So addressing the letter, the background, the why, does not assist us much, except perhaps to delay the further progress of the hearing of the testimony itself.
Listen, there's a second issue that I'm going to ask your guidance for. I was not here yesterday, and I actually tried to see if the transcript was uploaded yesterday. What I've noticed, and what is patently deposed to by Mr. Matlala, is that in addition to whatever is stated in paragraph 109, and I submit you need to read it together with the other paragraphs and in the specific contents of the AFTA judgment, Mr. Matlala specifically seeks to enforce constitutional rights that he says he's entitled to. Now, that issue seemingly has not been dealt with, and that's why I said, please forgive me if you did deal with it. I did speak to the juniors about that particular aspect. And the only question that I'm seeking clarification from you on at this point in time